Welcome to the Jurist Law Podcast.
Welcome to the Jurist Law Podcast with Kimbro Stevens and Shane Cox. Kimbro serves as managing attorney and Shane as chief legal counsel at Jurist Law Group. With rich backgrounds in healthcare and elder law, they help families navigate the complexities of long-term care, asset protection, and estate planning. I'm Lisa Mosby, your host, and today we're talking about one of the biggest concerns families have when long-term care becomes necessary, whether a nursing home can force the sale of your family home, and what options Arkansas residents have to protect it. Welcome, Kimbro. Welcome, Shane. Thanks so much for joining me today, gentlemen.
Thank you, Lisa, for having us.
Thank you.
You know, one of the biggest fears families have when a loved one needs long-term care is losing the family home. Where does that concern usually come from, and how often is it based on misunderstandings about how Medicaid works?
I think a lot of the concern comes from the misunderstanding, actually, as your question, and that just to be straightforward with you, Arkansas allows elderly people, whether or not they're single or married, to have a residence and also get on Medicaid, which is the service that pays for nursing home care when you're broke on paper. Okay. So, of course, I know we could unpack some of that, what that means, but essentially, there are businesses that make a living, essentially, and they tell their clients to sell their house, and in some of the different facilities, it's just a common thing that happens, and it's just bad advice because, as I said, Arkansas lets you have a residence. So what's essentially happening is you got certain businesses trying to profit from the sale of the house so that they'll get private pay until the person no longer has any money whatsoever, and then Medicaid kicks in. There you go.
Yeah, so essentially what happens is a lot of families come to us and they say, well, the nursing home told us to sell our house and pay them, and after they've paid us all their money, we'll help you get on Medicaid. But that's not true. That's not the reality of it. Everyone can qualify for Medicaid with a home in Arkansas. So we counsel clients a lot with that issue. And now there are things that we can do to protect that home also after a person passes away, and that's for another question. But essentially, you do not have to sell your house to qualify for Medicaid in Arkansas.
And then many people worry that the state will immediately take their house if they enter a nursing home. What actually happens to the person's home while they're alive and receiving care in a nursing home?
So that's a really good question, and I'll take this one too.
Sure.
So there is a lot of things that come along with the Homestead exemption, and even just the interplay between that and the Medicaid rules and regulations. But essentially, at the end of the day, even though the elderly person might not be physically residing in their house, doesn't mean Medicaid can come and try to take their house and sell it. Any kind of adverse action like that has to essentially await the elderly person's passing. And then basically what happens is Medicaid makes a legal claim in, like, probate court, for example, showing the court, well, look at these $200,000 in medical bills we paid for this elderly person's life, so it wipes out the house. So what we do is we counsel our clients and techniques to avoid that. And there's some really great things in Arkansas law that helps us do that.
Yeah, and just to piggyback onto that, the home basically stays where it's at. The situation there is, if the person is on Medicaid, they can't use their money to continue to pay for the upkeep maintenance of the home. If they have a mortgage, their money has to go first to the nursing home. And so sometimes it becomes more of a practical issue rather than it is a legal issue of how that home is going to be maintained. So again, we counsel patients that they can keep their home, but there may be some practical implications of what's going to happen with it. But otherwise, you're allowed to keep your home. And the other important thing is the reason why Medicaid continues to claim it as an exempt asset is because the applicant has an intent to return home one day. And that's key to the process of Medicaid leaving it alone. If for some reason you tell Medicaid, oh, I'm never going to come home, well, then they can count it as a resource and it can deny you coverage. But that is never the situation, because everybody wants to come home at some point. Whether or not they can come home, that's not really relevant. As long as you have your home, you have an opportunity to go home and you can pass away there on hospice or something of that nature. So Medicaid allows you to keep your home as long as you have an intent to return home. And the only other issues are, practically speaking, is the affordability of maintaining the home while your money goes to the nursing home.
And how does the situation change when someone passes away and the state begins to start looking at estate recovery? You kind of touched on it a little bit with that last answer, but can you be more specific about that? If the property is in a trust or other type of legal entity, can the state go after it or not?
It's a good question. So if it's in your name, being, if it's an individual who's single, it's in their name single. If it's a married individual, it'll go to the surviving spouse typically. And then when that person passes, essentially Medicaid. So for a single person at the death of his or her dad, married couple, the death of the last surviving spouse. But if it's in their names and and I'll say this typically, if it's in their names and one of their beneficiaries, usually their children, want to have the property either transferred in their name, deeded in their name. If it's like a bank account, of course, be able to access the funds from the bank account, then they'll have to open up a probate. And that's where Medicaid, not necessarily the nursing home, but specifically Medicaid, that's where they do their clawbacks.
Yeah, so what happens is Medicaid allows the house to stay in the family, be owned by the recipient of Medicaid, and then upon their death, typically the house will go through a probate to the heirs. Now, there's a way to avoid that. I think we may have a question on that in a minute. But essentially, if you haven't made arrangements to avoid probate of the house through either a beneficiary deed or that you had already placed it into a residence trust that's exempt from Medicaid as a resource prior to entering a nursing home at least 5 years, then Medicaid will file a claim in probate, and they are entitled to the sale of the home to pay their funds back. But again, the one thing that Shane mentioned is a joint ownership. So if you're married and your spouse is still living in the home, they're not going to get it because the spouse can continue to live in the home without fear of Medicaid. You can also have a disabled child that can receive the home. So if you have a disabled child, that's another way to avoid Medicaid recovery. Also, if you have a child that has assisted the recipient at home 2 years prior to going into a nursing home, that child can also receive the home free and clear of Medicaid. So, there are always exceptions to the rule. The general rule is if you die owning a home and you're on Medicaid, the state will file a claim in probate. But again, there are other ways to avoid that, all the way up into including a beneficiary deed.
A lot of rules and regulations.
Yes.
Yeah.
And I know I hear the word "it depends" often because I know it's case specific, but we want to give some general rules or general ideas to our audience. Can you gentlemen walk us through some legal strategies that may help protect a home when families begin planning ahead for long-term care? I heard so many things, the 5-year look back, different rules if they're married. Can you clean some of that up for us so that the listeners can better understand?
Yeah, sure. So I'll take it from the top, honestly, with the current way Arkansas law is, and this is the least restrictive method, would be to at least have beneficiaries listed on your assets, and if you own real estate, have a beneficiary deed. Because right now, as the law sits, and it may change, is that it essentially, if that's the case, and there's some certain rules, and there's a lot of legalese that you need to make sure your beneficiary has, but if it can be recorded before the person passes, this is a good example of protecting at least from Medicaid. Not from all creditors, I can't say that. There's all kinds of creditors that can cloud your title, but not Medicaid, and that's Arkansas only right now. So that's...
Yeah, and then that's assuming that you haven't done any pre-planning prior to the 5 years. The Medicaid allows in this state, which is not typical of other states, that a beneficiary deed they allow to pass to a beneficiary free and clear probate and free and clear Medicaid recovery. So that is always an option for people that haven't planned. But the best plan, in our opinion, is to do a residence trust for the home at least 5 years before applying for Medicaid. And when you do that, and the residence trust qualifies as a non-countable resource to the applicant, then it's already out of the applicant's estate, and there is no probate, and there is no claim against the home. And the reason we like and we call that, I should say, a lot of people call it a 5-year look-back trust, and that's because if the trust is done 5 years prior to applying for Medicaid, it's considered forgotten. Medicaid will never count it as an unauthorized transfer or anything during the 5-year period. So we counsel clients a lot who are early in the process of pre-planning their estate to always consider a residence trust when they're doing their plan. And then they'll never have to worry about Medicaid in the future coming back and taking their home, even if it's sold while they're on Medicaid, which is a key factor, because then you can sell your house out of the trust while you're on Medicaid, and the proceeds will not be counted against you, and it will not disqualify you for Medicaid. So again, the best practice is a Medicaid asset protection trust. That's what we refer to them, and we place the residence in it.
Well said, Kimbro. Thank you. Can you share an example of a situation where early planning helped a family to protect their home that might otherwise have been taken?
Where we found the situation, I think it is at Kimbro's kind of position in the process, which is generally a crisis. In other words, the person, whether or not they planned or not, they need to file a Medicaid application. And so where we reap those nice rewards is that they've come to me first, ideally, and I've set them up a 5-year plan, a pre-plan, a trust, essentially help them create, draft, hand tailor a certain trust that's going to meet their needs, and then anticipate the things that they're currently going through, 5 years later, hopefully at least, or at least 4.5 years later, or 3 years later. It's not the end of the world, but at least you've done some pre-planning. And so I have numerous clients. I can't really pick any specific one because there's just, we see them a lot where they actually do come back to us and meet with Kimbro. And sometimes all, if not, it seems like a lot of times I see around the 80% area of their assets are still protected for their family. And also, the state of Arkansas is paying their nursing home bill through Medicaid.
Yeah, and I can really speak to that mostly because in our practice, Shane does a lot of the pre-planning. I do most or all of the crisis planning. That's when someone hasn't planned ahead, and now we're having to do the best we can to protect as much as possible. But I can tell you that it's very often that someone will come in a crisis to my office, and they'll be they'll be all smiles saying, I have a trust and my house is in it. And most of the time, it's not a Medicaid trust. It's a revocable living trust. And they've been told by prior attorneys and stuff, this will protect their home. And I have to tell my clients, unfortunately, that is not true. A revocable living trust counts as a resource. So not just any estate plan will work. And so it happens over and over again. And it can be devastating to families, particularly if they have land in addition to their residence in it, particularly farms in Arkansas. We have a lot of farmers in Arkansas, and they think they have this nice trust that an estate planning attorney did. And I have to tell them, but it's not good for Medicaid. And so we have a lot of gnashing of teeth and wringing of hands. But what we do is we can tell clients, even when you haven't properly planned, in most cases, we can still save the house by executing a beneficiary deed, but you can't sell it during the lifetime of your beneficiary. But also any available cash or other thing, we can typically save about half. Now, when I say half, that means that it depends on how the estate is made up. But again, you can always save money. But you know what? If you'd planned ahead of time, you could have saved all of it. So that's the lesson to be learned. You can plan ahead to protect 100% of your estate. But if for some reason you tried to plan and the plan was not very good because you didn't have a Medicaid lawyer helping you, or you didn't plan at all, there's still ways to save assets. So, that's the hard lesson to learn. you know, getting people to come before they are in a crisis. And that's always the case. You know, typically most people don't plan.
I hear the beneficiary deed over and over, and I'm curious what challenges tend to arise when people try to address home protection after someone has already entered a facility.
So again, that's kind of a crisis, and I handle those. So when someone comes to me and maybe they have a trust that doesn't qualify, we have to deed the house back to the family, and then we execute a beneficiary deed. What that does is that makes them eligible for Medicaid because it's not a resource, and Medicaid is not going to come back after you pass away to take it from you. Unfortunately, you still don't have the resources to pay for the maintenance of the home, and the family usually has to take care of it. If for some reason they decide that, you know, we can't afford to do care and maintenance and utilities and so forth, that the family may still sell it after we put it back in their name. See, once we put it back in their name, we qualify. But then when it's sold because they can't continue to pay for it, then we do what we call a Medicaid spend down, and we spend that money down. But you don't have to spend it all. And that's, you know, that's what we encourage people to say. We can still save about half of the equity of the home. And we do that by making gifts to the family while we qualify for Medicaid. And then we pay through a waiting period. The result of that is we can usually get Medicaid about half the time that it would have taken if we just paid all our money to the nursing home. But then again, the beneficiary deed is kind of like a trump card that you can throw onto the pile and say, okay, I'm going to qualify for Medicaid, and as long as we're willing to maintain the home, we can still walk away with the full value. The beneficiary deed is really a lifesaver for a lot of families, because otherwise they're looking at liquidating their home and not keeping anything. And typically the nursing home will say to you, sell your home, pay us, and then we'll try to get you on Medicaid later. And I can't tell you how many people do that when it's not necessary. So again, the beneficiary deed is a lifesaver for many families.
Thank you so much for that detailed description. Here's where we want to wrap up today. For Arkansas homeowners who want to make sure that their house is protected as part of a long-term care plan, what steps can help put that protection in place early?
Best practice for us is to make sure you draft a trust that qualifies for the protection ahead of time from possibly going into long-term care and needing Medicaid. You really, these same trusts also have creditor protection, which I think is notable because you just never know what's going to happen as we age, especially if we get out in traffic. There's all kinds of problems. And sometimes, you know, you have disabilities that prevent you from being able to take care of all your financial affairs. So there's ways to prevent that, and also just bad spouses for your kids that seem to be wanting, you know, to possibly make a claim against some family property. There's all kinds of ways we can protect that and also still qualify you for Medicaid. So the right trust.
Yeah, and you know, a trust is like a car. There's all kinds of vehicles on the road. They all have different features, options. And so just any old trust won't do. You really need to seek advice from someone who actually practices in front of Medicaid, not just someone that says, well, I'm an elder law attorney and I know a little bit about Medicaid and I'm going to do this trust. Even so, there's a lot of misunderstandings in the estate planning community. They really don't understand the inner workings of these trusts sometimes. So you really need to have the proper trust, have the proper professional help you. But yes, the best practice is to create an asset protection trust at least 5 years before you need Medicaid, and to properly fund that trust, because a trust without funding means you don't put your house in it. You may have a trust, but you forget to deed it. That's also a bad outcome. So again, seek professional help early so you don't have to worry about the consequences later.
That's right.
Kimbro, Shane, thank you so much for your insights today. And to our audience, thank you for tuning in to the Jurist Law Podcast with Kimbro Stevens and Shane Cox. For more information or to connect with their team, visit juristlawgroup.com. Please like, subscribe, and share the show with somebody who might need it. We'll see you next time.
Thank you, Lisa.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.